continuar con la siguiente mesa de debate. Esta mesa de debate también va a ser toda en remoto. Vamos a hablar sobre el New Tech Investment Disputes. ¿Is Investment Arbitration APP for it? Es un poco el tema de debate. Va a moderarlo Lluís Paradell, Counsel de Freshfield Bookhouse Deringer, en Madrid y en Roma. Marik Paulson, Senior Advisor, Albright Stonebridge Group, Vicepresident, Global Institute for Peace Studies en Bahrein, y Thomas Walsh, Special Counsel, Freshfield, Bookhouse, Deringer y Nueva York. Creo que ya deben de estar conectados los tres, si la cosa va bien. No sé si Lluís me recibes, y si me recibes, pues te doy paso. Por supuesto, antes de dar paso a Lluís, como siempre, agradecer a Freshfields, que es otro de los colaboradores que están con nosotros estrechamente arropando y empujando este sexto Open de arbitraje. Lluís, estamos contigo. Cuando quieras, la mesa es tuya. Adelante.
Muchas gracias, Fede, y muchas gracias a Javier, o los hermanos gemelos de Javier, por la organización y por habernos invitado. Vamos a hacer esta sesión en inglés. O sea que, welcome everyone to this Freshfields session on new tech investment disputes. Is investment arbitration up for it? And before we get into the discussion, I want to thank my colleagues Laura Lozano and Alex Alonso for helping me and our panelists organize this session. Let me explain the topic first. New tech, innovative technological products and services, be them digital economy, companies, social platforms, internet, app services, disrupt states. And therefore, they are exposed to potential adverse regulations. Why is that? This is essentially because these products and services may be regarded as encroaching upon public interests, such as privacy, consumer safety, national security. States are responsible for protecting these public interests. However, existing regulations are often ill-prepared or even undefined to deal with these products and services. Let me give you a couple of examples. When Uber entered the Chinese market in 2010, the host government did not have regulations for ride-sharing services. So it developed and implemented regulations right then that essentially precluded Uber from executing its business. The same has happened with Uber and other car-sharing providers in other jurisdictions. More recently, the Trump administration issued an executive order prohibiting transactions with TikTok due to alleged national security risks posed by the company's collection of user data. So when these situations and potential disputes arise, and indeed they do arise, as we will be seeing today, questions also arise. Will these new tech, digital economy, social platforms, internet, and app service investors be able to turn to investment arbitration? Will there be any issues in their ability to rely on investment treaties? Or are there features of this sector that need to be taken into account? For example, are apps investments, or are they investments in the territory of any given state? In order to discuss these and other related issues, we are very pleased to have two very distinguished speakers, Marik Paulson and Thomas Walsh. Marik is a lawyer by training, is based in Bahrain, She's an expert in international law and arbitration, and currently a senior advisor at Allright Group, which is a commercial diplomacy and global stakeholder engagement firm led by the former Secretary of State, Madeleine Albright. And Tom is a special counsel at Freshfields, U.S. international arbitration practice. He serves as counsel and arbitrator in disputes arising in tech and biopharmaceutical sector. Tom will speak first for 10 minutes or so, and Marike will follow for 10 more minutes. We will then hopefully have time for comments. The online participants can write in the chat, and I will read the comments or questions to the speakers. So Tom, the floor is yours.
Thank you, Luis, for the kind introduction. I agree with your assessment. These are both exciting times for tech, as well as challenging times. I'm sorry,
I can hear an echo. Can we?
I hear that as well.
I think it's a matter of putting off microphones.
Is it better now?
Yes.
No.
Yes, go ahead.
Yes, okay. I'll plow ahead and you let me know. Is that better?
Just go ahead, Tom.
How about now?
Fine.
Okay. So I'll go ahead. The issue raised by Luis: what do tech companies do with government scrutiny? The question I have for you both: shall I log back in and you go ahead without me, or shall I go ahead? I'll go ahead. So faced with government scrutiny, it raises the question of what can tech companies do? They have a few options. We'll talk about one of them. That one being, of course, investment security claims. A quick word about how companies can actually use these treaties. There is I think, misconception that they are really just used for the cases like Venezuela, where your products are expropriated and you bring a claim for damages. It's a bit simplistic for the tech world. The reality is the use of investment treaties is far more nuanced. I urge tech companies to think about investment treaty claims as a negotiating tool. They can use a claim or even just the threat of a claim as part of their strategy to try to push back on government regulation that misses its mark and bleeds into what we would consider mistreatment. Now, of course, if those negotiations fail, the tech company can always use the investment treaty claim to seek damages and an award. But in the first instance, I would suggest that companies think of it as simply one of their tools in the negotiating process. Now, how do you go about a successful negotiation? I mean, certainly to maximize your negotiating leverage, tech companies will want to ensure that they present a strong claim. There are a few things that companies can do to achieve that. Now, with our limited time, and it appears now without an echo, I hope no one else is hearing an echo either. I will touch on two. First and foremost, tech companies should confirm that their foreign investments are structured to receive investment treaty protections. This perhaps goes without saying. However, we are seeing tech companies caught off guard by government mistreatment. Why is that? Well, I would say it's because government regulation of tech companies is coming in inappropriate ways from not just the states that we would expect as common respondents in investor-state arbitrations, but really many others. Perhaps the greatest example would be the United States and several European countries. A case in point would be the U.S. government's recent actions against Chinese tech companies. There, an investment treaty does not exist between China and the United States. And as a result, Chinese tech companies are unable to assert treaty claims against the U.S. unless they just happen to structure their treaty through another jurisdiction, such as Singapore, that does have a treaty in force. With this in mind, tech companies should ensure that their key foreign investments are structured to receive investment treaty protections. This can be done reasonably easily and simply with a little bit of advice of arbitration counsel. Now, importantly, if tech companies do need to restructure their investments to receive treaty protections, they should bear in mind that that restructuring needs to happen or be completed before a dispute arises in order for the company to be able to invoke the treaty protections. So in short, it's better to review investment treaty coverage sooner rather than later. The second point that I want to touch on is the presentation of the tech company's claim. Even when an investment treaty is available, the foreign government that's mistreated the company may question whether the company's investment actually qualifies as a protected investment under the treaty in question. Now, to maximize their negotiating leverage, tech companies will want to make clear that their investments meet the definition of a protected capital I investment under the treaty. Typically, this shouldn't be too hard to demonstrate. Most investment treaties define protected investments to include, quote, every kind of asset, end quote, and include a non-exhaustive list of examples. Common examples include tangible and intangible assets, shares in companies, IP, and contractual rights. And assets are generally understood to constitute, in the words of the UN, everything of economic value, virtually without limitation, end quote. Plainly, this is a broad definition. Nonetheless, in opposition to tech company claims, there is a somewhat common assertion that tech investments effectively float in the cloud, that they're detached from any particular jurisdiction, and as a result, these investments may not qualify as protected assets or fail to meet the requirement in most treaties that the foreign investment be in the territory of the host state. Now, I would suggest that this argument misunderstands the nature of most tech companies' foreign investments. And I think prior claims by tech companies are a useful illustration of this point. Luis, in his introduction, mentioned Uber. There are two ride-hailing companies that have recently initiated investment treaty claims, both Uber v. Colombia and Espiritu Santo versus Mexico. Now, in its notice of dispute, Uber described its investment in Colombia to include effectively three things. One, shares in a local subsidiary. Two, IP, including the right to license its app and the Uber trademark. And then three, contracts with drivers and riders. Now, shares in local subs, IP, and contracts with parties in the host country are quintessential examples of protected investments. Indeed, the Colombia-US FTA, under which Uber sued, specifically identifies all of them as protected investments. In the same vein, if we turn to Espiritu Santo's notice of dispute, it describes its investment in Mexico as including 1, shares in a local sub, and 2, a concession with Mexico City. Now, Espiritu Santo, despite its name, is a Canadian company, and it asserted its claims under NAFTA. NAFTA expressly identifies shareholdings in local companies and concession agreements as protected investments. So again, clear examples of big I investments under the applicable treaty. Now, there are 2 older cases in the tech space that are also illustrative of this point: Unisys v. Argentina and IBM v. Ecuador. Now, IBM's and Unisys investments related to information storage and management services. These investments involve contracts or concessions, in at least one of them, again, shares in a local sub. So again, clear examples of protected investments by tech companies in the territory of the host state. So these are 4 kind of quintessential examples of investments, all clearly protected under the applicable treaties. This, I think, debunks the usual critique of tech companies' foreign investments as not qualifying as investments. There are perhaps, though, harder examples. Now, I'm not aware of a case that involved an investment that consisted of a website or app that did not also have a local sub, IP, or user contracts. But for the sake of discussion, we can imagine one. Let's take, for example, the case of an app in which is subject to regulatory restrictions. And that app deals with either providing a search engine or video streaming services. Now, treaty terms certainly vary, but these web-based platforms would likely still qualify as protected investments under the broad asset-based definition that we discussed a moment ago. So why is that? Well, the answer is in how the business operates. Put simply, web-based platforms typically provide users with content in exchange for their data such as search history. And the platforms sell advertising or placement in search results to companies that wish to reach the platform's users. Again, most treaties expressly protect contracts like those with advertisers. Now, data is not expressly protected by the terms of treaties, but data is an intangible asset that should qualify as a protected investment because it has economic value. In fact, data is how the web-based platforms make money, so plainly, it has economic value to them. So as a result, these web-based businesses should qualify as protected investments. In addition, in our hypothetical, the investment occurs, at least in part, in the territory of the host state. Users receive content and advertising on devices located in the host state, and that content and advertising is often targeted to the host state market. That content and advertising may even originate in the home market and simply be displayed on the foreign-owned website. If we take, for example, my vacation to Buenos Aires, which was postponed due to the pandemic, had I visited Buenos Aires and while there visited a website owned by a U.S. company, I'm likely to receive advertising while there from companies that paid the website to advertise specifically to the Argentine market. If I were in New York, I would receive different advertising, likely tailored to the New York market. If I were in Madrid, Madrid advertising, and so on. Furthermore, to reach users in the host state, these web-based businesses rely on local telecommunications companies and infrastructure. These are all indicators that even web-based foreign investments can meet treaties' territoriality requirements. So in short, even foreign investments by tech companies that seem to float in the ether should be protected under the definition of investments under most investment treaties. So I believe I'm at my time and relieved to not continue to echo, I believe. But just to briefly conclude, I hope to have left you with essentially 2 takeaways from this discussion. First, investment treaties are a powerful tool for tech companies that they can use to negotiate with foreign governments. And then second, tech companies should think early and often about whether or not they are, in fact, protected by the treaties they would like to access. With that, I will hand the floor to Luis or Marique. Thank you.
Thank you very much, Tom. So, in your view, there is a much difference between, although there are differences in the nature of the investments, but in terms of qualifying as investments under treaties, there are that many differences that may prevent the application of these treaties. I turn to Marique to see whether we can to see whether she agrees or not, and whether she wants to expand in our fields as well. Thank you.
Thank you. I'm going to pray first because there were echoes and then Thomas jinxed it. Don't do that anymore. And we're talking about tech, and I find tech, I think, the most anxiety causing thing in my life right now. And second, Thomas, I don't think that you can protect investment or tech from me, an angry mother. So with that, I'm going to change the topic a little bit. The question, I think, was, could tech, whatever all of that is, sue states under a BIT? And what I'm going to look at is, could states sue tech, or at least not get sued by tech? And I want to show you this old school. I don't know how to split a screen, but look. You need to read this. This is the book that's going to be the Bible for all of us. And I'll start with a quote. The problem isn't one particular technology, but the use of technology to manipulate people, to concentrate power in a way that is so nuts and creepy that it becomes a threat to civilization. And all moms worldwide will agree. Now, today I saw a headline from CNN. It looks like the House has issued a report that accuses big tech of monopoly power. Now, quickly sort of tapping into what Thomas said, when you look at foreign tech wanting to sue states under BITs, there are a couple of hurdles. Thomas already talked about investment. It's a protected investment. It's not floating up somewhere up in the air. What can they do? How can they protect their investment? It relates to data protection, privacy, etc. And then there is the sort of the hurdles for investors when, they kind of want to sue states, but those states are just dealing with public policy. They're dealing with health. They're dealing with mental health. Big tobacco. Philip Morris, Uruguay, Philip Morris, Australia, very unhappy with the fact that they couldn't do what they wanted to do entirely. There were limits. Tobacco is not happy with the fact that they have to put certain images on their packaging. And so could tech really say there are no limits to how we want to reach our audience and the government should not get in the way? I wonder about that. So that's some food for thought for the investors who are trying to go after states. Now, again, tapping into that parallel universe of big tobacco. I remember a couple of years ago when I was in an office in DC, there were all these standing desks, right? And somebody said, sitting is the new smoking. I will tell you that social media and gaming is the new smoking. The difference that these tech giants are not going after office people or maybe adults who want to smoke, they're going after our children. So the question is the following. Can states hold tech accountable under international law? Or can they avoid state accountability under bilateral investment treaties when they're trying to protect and safeguard the mental health of their citizens? This could be a novel question. I mean, I don't follow all the news all the time because I don't have all those apps on my phone, but it's a question that we need to understand and we need to answer it. So I'm posing another question. Don't ask me questions in return during the Q&A because I don't know it yet. We need some more time to figure this out. Do states have a fiduciary duty? And do they hold the role of a trustee when it comes to the mental health of its citizens? Now, if they take on that role, will tech sue them? And will they have something to sue under international law? And at this point in time, we do know that there's public opinion, there's public pressure for states to do something. And I'm going to quote again from this book that I love, Zucht. Technology is a useful servant, but a dangerous master. Now, how can we explore that pathway of states kind of, how should I say it, sanctioning or slapping the tech's hands on the, slapping them on the fingers or whatever the English expression is? I'm going to tap into environmental damages claims. And with it, I'm going to use a paper that is about to be published in the India Handbook on Arbitration, knock on wood. It is going to be published by Karuna Nundi, a very known human rights advocate in India. She wrote a chapter, Arbitration of Claims Relating to Environmental Damage in India. And I think this is a really good source of inspiration for where we want to go. Here's what Karuna writes. When the state has an agreement with a company that damages the air, land, or water, and when an environmental damage has a close enough nexus with that agreement, then the state has an affirmative duty to act against private parties for such damage. Arguably, if the environmental damage has a close nexus with an agreement between the state and a company, then this duty may require the state to pursue the most effective remedy. So the Supreme Court of India has held under the public trust doctrine, remember that, public trust doctrine, that the state is the default trustee of natural resources, of land, forests, and rivers, and is under a fiduciary legal duty to take care of such resources for the benefit of. One of them is Burlington v. Ecuador. Now, what happened here is that Burlington, US-based, had acquired ownership interests in production sharing contracts for the exploration and expansion of oil fields in Ecuador. The arbitral tribunal applied the strict liability regime, and it found Burlington liable for groundwater remediation, soil remediation, and abandonment of wells causing mud pits. Now, park that idea of mud pits. And we go back into, we put on our Oculus Rift, and we go back into where I want to be, which is, could states have a fiduciary duty? Could they be the trustee when it comes to the mental health of its citizens, notably children? And could states, for example, use that as a defense when they are being sued under bilateral investment treaties by investors, by tech? Or on the other side of that equation, could states hold investors accountable if under bilateral treaty there are provisions on corporate social responsibility? And so when I look at that idea, I think there are a couple of things that we need to explore further. Its scope, it is who are the parties, and it is what exactly is the breach. When states are these trustees and do what they have to do because it's their duty, could tech say, if they're a foreign investor, there's an infringement, there is a denial of justice, there is a violation of fair and equitable treatment standards? That's the first question. Or could it be that the states are the ones who are going to maybe sue counterclaims or sue as the claimant? This needs to be developed. Now, we could look at two things here. There are national laws. States could issue national laws that they are enforcing against foreign investors. And those foreign investors could say that they are against it and that this could be something that falls under a bilateral investment treaty. Or we can look at just violation of international law. Now, and with that, I'm going to tap into another headline, which was, I believe, yesterday. Facebook has informed the Turkish government that it is not going to comply with a apparently controversial internet law. This law prescribes that internet companies, social media, tech app CEOs who are active in Turkey have to have one person, a point of contact that can engage in a dialogue with the Turkish authorities. And what is the argument? You can finish my sentence. It's, freedom of speech. Yes, I understand that, but there's also this other dark side of social media that we all know. Well, I don't, because I'm not on it. So then that's one. That's national laws that states will start to enact. Second, bilateral investment treaty. So I'm Dutch, so I'm going to go home, which is the Dutch bilateral investment treaty model. Now, I have to disclaim, I wrote a piece on that model, Dutch BIT, I was trying to tear it apart, but that was really because of the provision is taking place as we speak. ISDS reforms are underway. There are new model BITs that are anti-investor. I'm not anti-investor. I think ISDS is great, and I would do everything to protect that system. However, the Dutch model BIT also has provisions that are actually good. They relate to diversity, human rights, etc. So I'm just cherry picking here and using double standards. Now, the Dutch model BIT qualifies in Article 1 investment, rights in the field of intellectual property, technical processes, goodwill, and know-how. But it also says, before it quotes Article 1, it refers to the fact that contracting parties, so the states, have to regulate within their territories through measures necessary to achieve legitimate policy objectives, and one of them is public health, public morals, and social or consumer protection. In Article 2, it's about scope and application. There is again a reference to public health, safety, social, or consumer protection. And then in Article 6.6, there is a reference to human rights. Within the scope and application of this agreement, the contracting parties reaffirm their obligations under the multilateral agreements in the field of environmental protection, labor standards, and the protection of human rights to which they are a party. Now, Hillary Clinton has said women's rights are human rights, and Judge Gabriel Kirk MacDonald, who is part of our international arbitration community, has said civil rights are human rights, and I'm saying children's rights are human rights. And so here we go to Article 7. That's the magic bullet. Corporate social responsibility. Principles of corporate social responsibility that have been endorsed or are supported by that party. And then again, it refers to the United Nations Guiding Principles on Business and Human Rights. I think we have something there. And I think that provides us with a hook. And with that, we need to go back to that role that governments play, the public trust doctrine and the state as a trustee and protector of mental health. And with that, I'm going to end with Zucht. It is 9 o'clock here in the evening, so it's time for some, evening reading. And I want to share something with this audience because I'm not sure you know, and you should. And if you don't, now you know, and you should tell your children. Did you know, Thomas and Louise, that you are in a filter bubble? This means that although you think that the platforms you use are neutral, they filter contents in a way that's invisible to you, and they go into the sort of more extreme news items by using algorithms. Then the other thing that I found really interesting is that not me, because I'm not on social media, is that you are in a bottomless bowl. And that means that, for example, when you go to the movies or you watch a movie, well, we're not going to the movies now because there's a lockdown. You watch a movie, it starts, and then it ends, and then you see the credits, and it's over, right? Here, news feeds on Facebook and other platforms are endless. Endless news feeds work on dating apps. They work on photo sites like Instagram. They work on Facebook. YouTube, Netflix, and Facebook use autoplay on their video because it works too. Next thing you know, millions of people are sleep deprived from binging on videos, checking Instagram, or browsing Facebook. And you all know that that is what you do. But here comes the serious part of my intervention. And that kind of hits me straight in the heart and the soul, which is children. And this is what this author, Robert McNamee, which I can't pronounce as a Dutch person, is going to work on. And he can count on me as a partner. Facebook Messenger is designed to introduce elementary school kids to texting. Each time video game technology improves, more players get addicted. Texting has also demonstrated addictive powers and undermines personal relationships by enabling emotional interaction without immediate face-to-face feedback. A growing percentage of children prefer the hyperstimulation of virtual experiences to the real world. And I know this from a lot of pediatricians that this is a real threat to children and teens. So here's what this author says. We put tech on a pedestal. That's a mistake. We let the industry make and enforce its own rules. That's a mistake. We trusted them not to hurt the democracy and not to hurt our children, and that's a mistake. So with that, I conclude that, Thomas, I don't think you can protect investment or tech from me and from my wrath and angry mother. And we're going to follow up and we're going to see how we can, let's just channel our Kennedy, don't think what your country can do for you, but think about not how you can help tech, but how you can help states protect our children. Thank you.
Thank you, Marike. Extremely challenging and interesting, thought-provoking. My question would be, but that is a rhetorical question, really. Is the system, is the current investment treaty regime fit to the fit to face those challenges? Are the exceptions that some treaties provide or that international law provides enough to meet those challenges? Tom, a question I have on your presentation is the following. You say that the investment would qualify, that the new tech investment would qualify, and you mentioned aspects of, for example, app services that would qualify because they happen in the territory of the host state. My question is, do you see tribunals slicing up the investment so that the investment that would qualify would only be those aspects that occur in the territory of the state? Or would they take a holistic approach and say, well, since there is some presence in the state, something is happening in the territory of the state, then the whole thing qualifies, the whole investment, the development of the app, and all the contribution that the developer must make in that app would qualify as investment?
Great question, Luis. And I believe there are prior awards that have grappled with this question outside the tech sector, and they have arrived at the conclusion that even if part of the investment is outside of the host country, it can still be considered part of the foreign investment in the host country if it is dedicated towards the economic development in that country or the economic purpose of the foreign investment. And I think perhaps SGS, the Philippines, is the most famous case in this sector, but there are several. And so I do believe that, even if part of the app hardware or individuals even supporting it are located outside of the host country, they provided that they are taking part in the foreign investment, even if indirectly, it would be part of the foreign investment. Now, if I may, just very briefly on Marike's very provocative presentation, I don't pretend to protect anyone from her or any other angry mothers, including my wife. However, I would suggest that the existing investor-state structure can protect people to the extent they need to be protected from technology. I think states are allowed to exercise their police powers. Really, the question is not whether they can exercise them, but rather how. And I think the cases we've been seeing in the United States right now, not investor state, but rather the actions the U.S. government's been taking against TikTok and WeChat, for example, those have been very heavy-handed. You wouldn't say those are surgical regulatory actions. They are literally putting businesses either out of business or nearly out of business and causing them to have to change everything that they do with a certain goal, at least put out there by the government in mind, but not certainly tailored to that goal. And so I would suggest that, as I said, the real question is, how, not whether governments really can regulate in an effective way.
I guess before Enrique reacts to that, I guess a question that arises here is whether the fact that these phenomena are not regulated, and so the regulation is taking place against a blank slate, really, would have an influence on how a tribunal reasons, because arguably arguments like the legitimate expectation, which we all know are being raised in almost every single investment arbitration case, would be more difficult to run. What do you think, Marika?
So I couldn't everything. I also hear a small echo. Could you shortly repeat the question?
Well, my question was really, even before we get to the exceptions that may need to be used to justify state intervention in this sector, even the claimant may have trouble in arguing its case, since the new regulation that may be adverse to its interests it takes place against the blank slate. There is no prior regulation that you substitute, and therefore legitimate expectations may not be ready to be used in that particular case. It's
Yes.
just really not a question, but a comment.
So there are a couple of aspects. So one is obviously who is the claimant? Are we looking at a bilateral investment treaty where the state has regulated this, it has impacted the investment, and therefore the investor is suing? Or is it the state kind of holding investors accountable for the social responsibility? And indeed, what Thomas says, we have the current set of bilateral investment treaties, and now we have this whole new generation of bilateral investment treaties that kind of tap into the UN Sustainable Development Goals. But I think that this is new territory on the domestic level and on an international level. So those questions, what is interesting is we're beginning from scratch. And I know that's hard, and I think how are tribunals going to assess that? How are tribunals going to assess what the reach is of this regulation and to what extent it might infringe, or to what extent they were justified in doing so under those provisions of protecting, for example, the health, public health? We don't know yet. And one thing that I think is interesting, so Thomas referred to what is happening within the US space. And this is very hard. I've followed all of this. We've seen what the role that Facebook and Google are playing right now. And I think in a country like the US, this is going to be incredibly challenging. And with that, I kind of would like to use as an example the pandemic and the governance decisions around the world. I'm sorry, not obviously immediately putting the US on the stand, because this is right now depressing what's going on over there. But what we've noticed is this. In Europe, we don't see a uniform set of regulations to protect people from the virus. It goes from EU member state to EU member state, and it's almost a cultural thing. So my country, the Netherlands, there is a whole debate on whether or not to wear mouth masks, and the Dutch just don't want to. And the prime minister is pretty much begging them, and that's not the way forward. That a prime minister has to say, I'm just asking you to do the right thing. Whereas where I am in this part of the world, in the GCC, the government sets up a committee, sets up a set of rules that they add or change from time to time, and it's being enforced. And people comply. People comply. So I think that what is being described by these stakeholders who really tap into that world of tech and the impact on democracy and mental health is that it has very much to do with culture. So those regulations, you can't say on an international level, these would be the regulations that can protect people and especially children from the harm from social media and games. It doesn't work like that. There's this thing called sovereignty, and Falinari always says, sovereigns are like billiard balls. They collide often, but seldom go in the right direction. So we see really that implementation and government, that's going to happen on a domestic level, just like what happened in Turkey. And then the question is, how are we going to handle that on an international level? And I don't have the answer. The only thing I know is that over time, in the next couple of years, we're going to learn a lot more about the impact, about the negative impact, and something needs to be done. And let's go back to tobacco. Some decades ago, nobody really knew. And if anybody back then would have predicted what governments have now and what's happening on an international level, maybe decades ago, we would not have thought that the government could go so far. So I'm still optimistic.
Well, with this note of optimism, I think we need to close. I thank you both very much, and I thank the organizers again for this very interesting event. And we will, I'm sure, hear a lot more about this topic in the near future. Thank you.
Thank you.
Thank you, Luis.